offenders is what I'm getting.
Okay, so we are recording and let's get started. We're grateful to have Clark Harms and Denise Porter providing this special training to attorneys who represent inmates at the Gunnison Prison. This is a great opportunity for us to learn how to represent inmates more effectively before the Board of Pardons and Parole. And I'm pleased to introduce Denise Porter. She spent nearly 17 years as a trial attorney at the Salt Lake Legal Defender Association, where she specialized in capital mitigation as well as resolution and sentencing strategy for violent felonies. She's a former board member of both the Utah Association of Criminal Defense Lawyers and the State of Utah Indigent Defense Trust Fund. She was appointed to the Board of Pardons and Parole by Governor Gary Herbert in March of 2016. Clark Harms serves currently as the Board of Vice Chair. He practiced law in Salt Lake City and worked for the Salt Lake County District Attorney's Office from 1995 until his appointment to the board in 2006. While at the District Attorney's Office, he was assigned to the Special Investigations Unit and Wasatch Range HIDTA Task Force. He also served as a Special Assistant to United States Attorney. He served as a unit chief of the Special Investigations, Gang Prosecution, and General Felony Prosecution teams. He served on the Board of Pardons and Parole Chair from 2010 to 2014, and then as a Vice Chair from 2007 to 2010, and again now from 2019 until present. So we are pleased to have Denise and Clark do this presentation and training, and this will be a kind of an informal setting, so feel free to unmute yourselves and ask questions. I turn the time over to Clark and Denise.
Thank you very much. Thank you all for being here. And like Katrina said, pretend we're all in one room and you're going to get all your questions answered today, and just speak up and ask questions. We'll start out and kind of follow the outline that was sent out and kind of just go that way and follow the outline, but don't wait for the subject matter of your question to come up if you don't want to. Just get in and talk about the things you want to know about now.
Good afternoon. Thank you all for joining us. Please also feel free to throw yourself on video so that we can have it more as a meeting format. And it can be a little more interactive. That I think probably will work best because we have such a small group. It is ideal for you to be able to talk to us about the questions you need answered, as opposed to just listen to us waffle on time and time again when we can be answering questions to help you in your practice. So the first thing I'd like to ask is how long each of you have been managing the your portion of the contract?
Denise, this is Cliff. I haven't been doing it very long, a couple months maybe. So not long is the answer.
Since June 8th is the answer to that, Cliff.
Thanks, Joanna.
This is David. I've been doing it for about maybe 2 years. Maybe 2 years, I'm thinking.
Shane, how about you?
Shane's also one of our newer attorneys since June. David and Dana and Richard are the three most senior. Rob is also our newer attorney. So we have a mix of new and old.
Okay, good. So let's just make sure that everybody's on the same page with like who the board is and what it is we do. You guys have all been doing criminal practice for quite some time. So, you know, after sentencing in court, if someone goes to prison, jurisdiction leaves the court and goes to some other body called the Board of Pardons. We are two of those 5 people. There are 5 of us on the Board of Pardons, and we make the length of stay decisions for everybody that's committed to the Department of Corrections. So we decide when they're going to be heard and what's going to happen. Then when they have that hearing, we decide what happens next. Release, parole release, termination release, which is a termination is minimum equivalent to time served. Rather than be on parole after their release, the termination is they're going to do a certain amount of time and then not have any more supervision. We can set a rehearing at that original hearing, and we can have a treatment that we require, things like that. We also determine when people who are on parole come back, issue warrants for their arrest and return to prison. We set the conditions of release. We adjust the conditions of release, and we decide when parole is ready for termination and they're free to be off paper.
The other thing that's important to note generally about the board is that we average between the 5 of us 15 to 16,000 decisions a year. And most of those decisions require a 3-person vote. And so the reason that that's relevant is that workload is heavy. And to make sure that we do a good job, we go through things as thoroughly as possible, but we also have to do it very, very quickly. And so as you're working through cases, know that that's the volume we're dealing with.
And even though we're happy to answer any questions you have about board processes, but we're going to concentrate on your area of expertise, which is someone's in prison, they're accused of a new crime, now what? So let's talk about that. They could be, while they're in the prison, while your clients are in the prison, they may be in any status. So they might be awaiting a parole release, they might be awaiting a termination release, or they might be haven't even had a hearing yet. They might be waiting for a rehearing. And so in each of those situations, what we do might change a little bit. The first thing that happens is generally the cases you get started out as a disciplinary violation, meaning that somebody in the prison has been cited by prison authorities for a violation of prison rules, and then it progresses. There, a separate investigation occurs by the Law Enforcement Bureau, and charges are screened with the county attorney, and then filed. There are 2 tracks, as you can imagine, going forward at the same time. One is the interagency, intra-institution disciplinary violation track, and the other is the separate screening prosecution track. When we receive notice of the disciplinary violation, if there's a parole release date, we may be asked by the Department of Corrections to rescind that release date and wait to see if new charges are filed. A rescission is a 3-person vote that just takes that date away and puts them in a holding pattern until the new case is resolved. When new charges are filed and we receive notice of that information, we almost invariably will stop whatever process we're in, whether we're waiting for a hearing or a parole date or release date. We'll rescind anything that we need to so that nobody leaves the prison, and then we'll wait to see what happens with the new case before we decide what to do next.
Know that if there's a pending first-degree felony, it will freeze everything almost immediately and through the entirety of the case. That you will not have a rescission hearing that will continue past that. Your date will be pulled, and then you will wait for that first-degree felony to be resolved. The other charges may or may not have that process be followed. If, for the most part, they will likely be held for resolution of those cases, but on an occasion that may not be the case, on maybe a Class A, maybe a 3rd-degree felony, but almost inevitably on all felonies.
The first practice pointer that we wanted to make sure you understood, people can only, as you can imagine, they can only stay in prison up to their expiration date of the current sentences that have been imposed. And about once or twice a year, we have someone who we have in custody has new charges pending and their expiration date's coming. So you may receive notice from the court or from us that the expiration date's coming and they're going to be released from the prison on that expiration date regardless of the new charge pending. That's obviously going to change kind of some of the things you have to do, but be aware that that's the first thing we want to do is let you know that that happens, and then it'll be up to the judge of the court in which the new case is pending to determine whether or not they're going to set bail or detain until trial, whatever. At that point, we're out of the picture and it looks just like a regular case to you until it's over. So just be aware that sometimes that happens. if an expiration date comes, we can't hold them like a holding facility for the new case if we don't have jurisdiction.
The other thing that's going to happen fairly immediately after the disciplinary action is that your clients are probably going to have a security level redetermination, and their security level is going to be heightened, and that's going to likely pull them out of programming or housing units, things like that, that they may have been doing something productive. They may not be able to continue that programming while they've lost that privilege level. And so it would be important for you to visit with your client about their current privilege level and what that privilege level means to them. Can they program? How are they housed? Because you don't want to be setting up a resolution in a case that puts the person in a position that they can't accomplish what you just agreed to.
Is there a certain time period to point down when you're raised to say the level where they keep you and you went to 1?
Say that again, Cliff.
So I know in the jail, there's time periods where you point down from maximum to medium to minimum. Is it similar in the prison system?
So if you've gotten a disciplinary and you get sent to a higher classification level, you can point down over time. Your client should be able to tell you what that time frame looks like for them, and when any kind of immediate punitive isolation may be taken care of. Each program, depending on where the person is held, also has different return times. And so somebody that might have been participating in HOPE in Gunnison will need to be in the right unit, number one, to return, and they'll need to have approval to return. And so your best source of information on that is your client and what they've been told in terms of their internal sanction. Because they will have gotten their internal sanction well before your criminal case is resolved.
The internal sanction is going to be what governs their housing and programming availability, not just simply the fact that a new charge is pending against them. The other thing, go ahead.
Oh, follow-up question, just this statement about setting someone up for failure. So what would that look like? So we know how to avoid that.
Okay, so setting someone up for failure. Here's an example of what could happen. You want them to go ahead and go back to treatment, but they can't get to treatment. You represent to the prosecutor they can go finish their residential substance abuse, and they can't complete that. Does that make sense?
It does make sense. I haven't, in just the proceedings I've observed so far, I just haven't seen that scenario even offer itself, but maybe.
And it wouldn't happen often because they're already in prison, but the lack of ability to reduce their risk is just something to have in the back of your head. If it's not coming up in negotiation, then it's not something that's coming up and causing you any heartburn. It will affect what we do on the back end because it's getting in the way of them reducing their risk, which is a consideration in obviously any kind of parole determination.
Okay, and I'll throw out, I'd love to hear from others in our group if they've seen that or how they're navigating that.
So when y'all get assigned the case, do you, as a matter of course, try to figure out what their status is in the prison? Do you look to try to get a copy of their file from us? Do you go in our website and look to see what our last order is on them? Or or do you just go meet with them and then try to figure all that out at the same time you're trying to figure out the new case?
I don't think I've gotten a file from the prison. I usually go online and check out the most recent hearing decisions and that kind of thing. Which brings up a question. You mentioned earlier that you decide when they're off paper. Does that mean that this expiration date that we see, you can modify that and make it shorter than it is?
Yeah, so expiration is just a mathematical function of the length of the indeterminate sentence. And so it's measured from the date of sentencing less credit time served. So served around here is, let's say you are accused of a crime, you come to prison on July 1st, but there's 90 days of credit for time served. We create an adjusted commitment date of April 1st in that situation, and then everything would be measured from that April 1st date, both the guideline and the expiration date. So the expiration date is the maximum sentence, but parole obviously will be before that. And if someone paroles and they are paroling successfully, you terminate that parole and be off paper as soon as 12 months, typically, or as the length of their sentence. But depending on how they do, there are guidelines that we look at to see how they're doing, if they've done treatment, things like that. I'm going to approach the camera and tell my computer to ignore this for a second. Sorry.
So you don't reboot.
But yeah, so most people do not stay in the prison for their full sentence, and most people do not stay on parole for the rest of their sentence. Typically, people are off parole if they're successful within 18 to 36 months. And right now, we're typically looking at folks for the first review of their parole by about 18 months out.
And that request is made by AP&P. The agent fills out what's called a termination report, and that comes to the board for review. For your purposes, you would want to familiarize yourselves with the supervision guidelines. They're a separate standalone document on CCJJ's webpage that go in tandem with the sentencing guidelines. And that gives you, it's about 8 or 9 pages, and it gives you the specific times that things can be submitted, reviewed, and what crime categories that those fall into. And so, very long answer, Cliff, yes, you can terminate prior to expiration.
Thank you.
Well, if anybody has any questions on the first part of the agenda, let's do those now. Otherwise, we're going to go to sentencing considerations. And I think that's probably where the most of your questions are going to come up.
So procedural questions prior to having a resolution and doing a sentence.
What is the process to get the file from the prison?
So once you meet with your client, you can have them sign a waiver, and then you can request a copy of our file, and our grandma specialist will send it out to you.
And that's the board file, Cliff, not a prison file.
Yeah, it doesn't say anything about the internal operations. It's just our decisions and like the prior PSR, stuff like that.
Okay, thank you.
Oh, that's great. So just to clarify, so a pre-sentence report, that's for the criminal case that got him in the Department of Corrections system, that's going to be in your packet, and we can get that rather than have to go through the Department of Corrections.
Correct. And in fact, if that's all you want, you can just ask for that. You don't have to get, everything. Because our file includes everything we've received about the inmate, including letters from their families, letters from victims, the police reports of the prior offenses, everything they've done, the entire length of time they've ever been in prison. So some of you, I know it's shocking, but some of you may be representing folks who are not in prison for the first time. And what you want to be careful is not getting everything from 1992.
The other thing to note with that file is when you get a copy of it, you can be confident that at some point, and there are different points in the process, but at some point your client has received a copy of all of that. It's called disclosure. We've all heard clients refer to things as a blue packet. That is the blue packet. That's what they get. They get it before every hearing, and they are asked at any hearing whether it is correct, whether anything they are aware of that is missing, if there's anything that needs to be modified. And so when you're reviewing it, it is safe to reference to your client as something that they should have already seen. In our file, the only thing that is not disclosed is what we call Section 2, because the files are still paper, and that is our work product. Everything else is disclosed, and it makes the entirety of the file. So that's helpful to know if you've got somebody saying they don't understand a document or haven't seen it. That would be hugely, hugely unlikely in terms of board file.
Is there a form that you have to get that waiver, or just do they come to you in all kind of forms?
Come to us in all kinds of things, but if you just get a waiver from your client with a letter from you on your letterhead saying I'm representing them in this case and I'd like a copy of X, Y, or Z, then that's going to be good enough.
Thank you.
So let's talk about sentencing considerations. First thing, as you know, the statute presumes a consecutive sentence for crimes committed in prison. And so a lot of what you will be doing is negotiating that presumption, I'm guessing. Not only the level of the offense, but then the presumption. A consecutive sentence means just what it says, that it will start running after everything currently expires. And so it'll set out the expiration date that much farther. The converse of that is a concurrent sentence. We will run a concurrent sentence from the earlier of the rescission that rescinded the date for the actions that form the basis of your charge, or from the date the actual criminal charge is filed, if that happens and we don't know about it. That's where we'll start from there and then run it forward. They're not going to get credit for time served against a new case for the time they were serving before the case arose. That makes sense. So we'll just start it either when we started holding them on it or when it got filed, whichever is earlier.
And then you can also presume that if it ends up being concurrent, that all of that credit is calculated into the new expiration date. That's not something that you have to worry about with the trial court.
And as you know, your clients are not going to be as concerned about the expiration date as they are going to be about either the guidelines or the minimums. And so, but just be aware that that's the effect of concurrent versus consecutive.
Questions on that?
All right, credit for time served on the new offense. I just kind of alluded to that. So sometimes we know that the case is coming before you do. And that's when the institution will send us, Department of Correction will send us a rescission request and say, such and such happened on this date. We want you to rescind their date and we're going to file charges. If we do rescind that date and later the charges are filed for the activities that form the basis, then we will start the new sentence if it's concurrent on the date we rescinded. Because we're in effect holding them now. They did have a release date. Now we're holding them on this new charge. And so that's when we're going to give the credit. If it's a consecutive sentence, obviously, then that sentence isn't going to start until everything else ended. And so consecutive sentencing really affects that end date.
So a judge's recommendation to you about credit for time served is kind of meaningless. Is that accurate?
Yes, because number one, we have policies that override that recommendation where we can tell you what we're going to do, and we're required to give credit for time served by statute. So a lot of judges are still in the old habit of making a recommendation or not making a recommendation. They can make the recommendation, but we're just going to, I told you what we're going to do with credit for time served.
Right.
If you get a concurrent sentence, you will be given credit.
But in effect, credit for a consecutive sentence means there's no credit because the sentence doesn't even start until all the other ones are over.
Does that make sense to everybody?
Yeah.
All right. Sentencing guidelines. Who wants to ask questions about guidelines?
How about I start out just to sort of hopefully get rid of any misunderstandings about how the guidelines apply in this situation. Does anybody believe that the 10 and 40% that you see referenced in the guidelines apply in this situation?
I did until you told me it didn't. Like.
Anybody else going to confess?
And remind me, this is I keep hearing well, if you get this, it's going to add 20% on. Is that what you're talking about? Because the question that's coming up is, what's my matrix? And I've kind of heard that's a shot in the dark anyway. So.
Okay, so that's Rob. You're perfect, and help me lead right into this. At the very bottom of the sentencing guideline matrix is a very small line that has confused people forever. It says if you get a concurrent sentence, you get 10% of your guideline added to your current sentence. If you get a consecutive one, it's 40%. Absolutely, if you don't hear anything else for the rest of this presentation, that does not apply here. The reason it doesn't apply is because that 10 and 40% only happen when you get a group of cases that are all sentenced together. If they are not sentenced together, your client is going to get what we refer to as standalone guidelines. They will get a complete, full, new set of guidelines based on the new conduct. There is nothing that merges into the old conduct, and any discussion, if the client asks you about 10 or 40%, is a misunderstanding of that. And so then when they get their PSR or they get their new guidelines and disclosure, oftentimes they are caught wildly unaware because it's a huge, huge difference, because it's not 10, it's not 40%, it's the full guideline. And so the term of art that we use here is a standalone guideline. Every guideline is calculated at the board. We have people whose job it is to do that. If you believe that there is an error in the calculation, you are welcome to make us aware of that, and we will double check it. But the number one thing to be aware of is when you're looking at sentencing guidelines, you will get a full new guideline for the new conduct.
In this situation, we treat folks who are in prison and commit a new crime after their original commitment the same as folks who commit a new crime and get convicted while they're on parole. They both get a new guideline for the new offenses. Now, if for whatever reason, and this doesn't happen a lot on your cases, but it does happen on parole violations, where they have multiple new convictions. Those multiple new convictions are all a single episode for guidelines. And so, for instance, if you have someone who gets convicted of riot 3 and ag assault 3, the ag assault is going to be the driving factor. And if they came out concurrent to each other but consecutive to the other case, that second case of the current ones, so the riot, would still be the 10% of
Second
that.
count.
It'll be the second count. So we will group them together, but you're going to get, it's like a separate episode. It's easier to think of that. If the episode is at the same time as sentencing originally or happened before sentencing, we'll lump them all together as one episode. But new convictions after that are new episodes and get new guidelines.
So where do we get this? Where do we get these standalone guidelines? Because I mean, I hope I'm not talking out of school here, but my early observation has been, I mean, when we sentence these cases, we don't get a PSR. We just kind of do them and move forward, which.
Yes, sir. Forward, you idiot.
So this is that's a great question, Rob. We would recommend that you always, if you can, get a PSR, because a couple of things happen if you don't. Number one, just like you said, neither you, the judge, the prosecutor, nor the offender know what the new matrix is going to be. But more importantly, you delay us seeing them. So let's say you have a new case and you get them pled to a third concurrent. Well, normally we would have an original hearing on a third-degree felony within 3 months of sentencing. But if you don't have a PSR, we have to wait and delay that to get APP to do a post-sentence report for us. And post-sentence reports for the board drop in priority behind pre-sentence reports for judges. And so sometimes it can take us 4 or 5 months to get those. And so now we've delayed hearing them by 2 months just to get the information that APP could have given the judge beforehand. So if you can at all persuade anybody to get a pre-sentence report before sentencing, it helps the client, especially if it's a third-degree felony.
And the post-sentence, one of two things will happen. You're either getting a pre-sentence or a post-sentence, either way. And so if the offender is talking to you about, well, I don't want to delay, I want to get this taken care of, that report is still going to be ordered. The other thing to know from a defense perspective is that a board post memo, a post-sentence report, does not interview the offender. And so there is no defendant's version of events included. If that is important to you as a litigator, you need to do the pre-sentence report because it is not included in the post-sentence report.
The other thing that you can do, if you get a copy of the guidelines or you go online to the Sentencing Commission website, which is a subset of the CCJJ website, you can kind of ballpark your own guideline and see the difference on what the different offers would be. Just make sure that you realize that the offenses that they're currently in prison on our prior offenses for purposes of the new offense. So they're always going to be one category above where they were before, because they, or at least they could be, because they're going to have more felony convictions than they did last time.
So I had a
And you can kind of gauge, you know, if you get an offer for a third consecutive or a second concurrent, you can see what the guidelines for those are, so you know what you're talking about.
So I just had a question, and this just comes from my lack of knowledge, I guess, and probably listening to too many people over like the last 13 years. But I have always heard from people, defense attorneys, prosecutors, consistently, and they're probably wrong. That's why I'm glad I'm hearing it from you guys right now, is that pre-sentence reports, and they send people to prison, that the prison basically does their own report and they don't even look at the pre-sentence report. That's not true. You guys do look at it though? I've just never.
I think the confusion is the guideline.
Oh, is that what it is?
Guideline in the pre-sentence report, we do our own.
Okay, so the report is important. Just don't really look too much into the guidelines for what they're saying.
We don't look at their guideline at all because we do our own. Because think about it this way, Mr. Heyer, if you've got a bunch of cases coming in together, each PSR's guideline is going to be wrong.
Mm-hmm.
We bring them all together. We have one file, not 20 or 5 or 6. And so those guidelines are not going to be, it's not that they're necessarily wrong when they're calculated, they're wrong as applied in our situation.
Okay.
And so quite frankly, we have 3 people now who truly full-time, that is their job. They are amazing. They are incredible experts on the guidelines down to the smallest intricacy. The report itself is really, quite frankly, one of the hallmarks of our file.
Right.
So I think that is where the confusion is. The PSR is where we get a lot of times information on restitution, information on the defendant's version of events, the official version, which could be at some points the police report version or something that has been a little more edited. But the body and the text of that and the background there is critical.
Thanks for letting me know, because I swear I've even had judges in the past tell me, doesn't matter, they're just going to redo it. So I need to.
That's just not accurate. We only redo it if it's if we don't get it in the first place.
Right. The only thing we redo every single time is the guideline, because number one, we have the experts in the state, not the 200 different people working for corrections that do it once in a while. And number two, there's no way they can anticipate concurrent consecutive sentencing. So they can't do it for that, right? Another important thing about the guidelines is that as you're looking at those and you're kind of guessing, trying to gauge what the effect of the sentence will be, you may have heard from different practitioners over the years that the guidelines don't really matter that much and the board will do what it does. The guidelines are where we start our evaluation of this case compared to all the other cases on every single offense that we look at, every single file that we look at. And so in the pre-sentence report, you can see whether or not somebody is counting a criminal history point or criminal history activities that aren't your clients, because that will artificially inflate the guideline if they're attributing something to your client that's not theirs. And so you're the check on that. You're the first opportunity to make sure that those are correct. We see this often where people have interchangeably used their sisters' names, but by the time we get them, that PSR from APP might have some stuff that is your client's and some stuff that's your client's sister or your client's brother. And it's important to weed that out beforehand so we can get an accurate guideline and an accurate pre-sentence criminal history calculation.
The other thing to know in terms of the guideline as a starting point, you all have been doing this long enough to know that there is sort of an average case within a category. There is an average, so to speak, forgery case. There is an average retail theft case. You know what that looks like. Those guidelines are what tell us the starting point for an average case. There are cases that are less egregious. There are cases that are more egregious. So know that that's why it's a starting point, but why it is somewhat flexible. But that's the starting point of the analysis for that crime category in that box in sort of its average form. Does that make sense?
The other thing from our experience with folks representing folks who've been accused of crime while they're in prison, you're going to get a variety of offers, and they're going to want a stipulation on consecutive concurrent, or they're going to say, well, this is, you know, their negotiations often include that consecutive concurrent piece. So it's really important to know how that's going to affect the outside date. Your client needs to know that. And it'll affect the start date. It's not going to, consecutive concurrent, like I said, doesn't really affect the guideline because they're going to get a standalone guideline. But it does affect when we start the guideline running. So if we get a case and the offense that you're representing them on occurred in the prison on April 1st, and we rescinded their date and had notice of something on May 1st, a concurrent sentence will start the new guideline on May 1st. But a consecutive sentence, the guideline won't start until sentencing for that offense. So that's the difference in that effect. And so you're going to need to know that as you're kind of looking at those offers to see the difference. For a little while, there were a lot of folks getting offers for thirds or A's, depending on the sentencing recommendations. That used to not be that helpful because there were no guidelines for A's, and so the offender wouldn't really know what he was buying into. There are guidelines for Class A's now, and so you can look at the guidelines and see what that guideline is going to look like based on that offer as well.
If workload allows, best practice would be to take your client rough estimations of the guidelines of anything that's been presented to them, as well as what it will do to their outside expiration dates.
And its shorthand for you would be, if you got the last PSR that we had, or even just the last guideline calculation that we did, you'd see what their criminal history score was, and from there you can just add in the stuff that is now a prior. So for instance, when we calculate guidelines and we're looking at criminal history, that never includes the instant offense. So the criminal history is actual history. And so what happens is, by the time you guys get involved, the current offense becomes a historical offense, and that's how the criminal history points go up. But it's a starting place, so you can figure out, you know, what does one new felony change them from a category, from a criminal history 3 to criminal history 4, and what does that look like on the columns, right?
Okay, questions about sort of those technical edges of things, either the consecutive concurrent or the guidelines?
I have a general question, and I've had several of my clients express concerns that the Board of Pardons considers the original charging document as well as the commitment order, and that they get additional, they call it silent time because of that. How does the board deal with the commitment order versus the information?
We don't have, so you're talking about the criminal information, like a copy of the criminal information?
Yes, yes. And
That,
they have,
that is not uniformly part of the file. What is part of the file is the PSR, and the PSR at this point is that official version of events is absolutely in the file, and so that will be part of the calculation. And so that's part of why you may want to make sure that you review the PSR as opposed to getting a post sentence, because that gives you an opportunity to review what we're going to see. If you do it as a post sentence, you never see that. So we will see a recitation of the facts, but that's done through a pre-sentence or a post-sentence report. We do not have a copy of the charging document in the file. On occasion, on rare occasion, we may pull something to look at when something procedurally doesn't make sense.
Or sometimes the sense doesn't, we can't figure out how someone got an enhancement. We don't know what enhancement was used because the JNC is silent. So we may look at the court docket to see what was filed, so if we can figure out the enhancement that was used. But the starting position for us is the judgment and commitment that is current, you know, the one that sends them to prison, so the commitment, and then the facts of the offense, and the defendant's version of the offense. It seems to me after doing this for this long, sometimes it seems like offenders think that silent time is really us just gauging their case against other people's with the same commitment. So someone who steals a car and gets a second-degree felony theft by receiving, and it's a car, and someone who steals $1 million from 40 different people and gets a theft by receiving, those, while they're going to be the same guideline, the one with the $1 million in restitution is going to look differently to us than the car, and consequently, we're going to analyze that based on the facts of the case and the damage that was done as part of the case, not just on the guideline. And it seems like some offenders justify the differences in their case by saying we're doing silent time because of this, that, or the other. And we don't even know how to do silent time because there's 5 of us that have to talk about it. So it's not that silent.
Can I ask a question about Class A misdemeanors? What we get a lot is guys that are in prison and they commit a new offense, whether it's assault by a prisoner or a riot or something like that, and the offer is a Class A misdemeanor. And the offender always wants to plead to the misdemeanor, be sentenced that day, be done, so that they can get in front of the board quicker. And so they don't, sorry, I might have lost you for a second. So they don't want to get a post-sentence report. They don't want to wait for a post-sentence report. They don't want to come back for sentencing. Is that counterproductive to plead them to a Class A and get it all done that day? Because that's what the offenders always want.
It is counterproductive in that it does not move things along faster. In fact, it can, as Clark said earlier, it can actually slow it down. It also takes away the ability for them to participate in an investigative report. It takes away your ability to react to that report. It takes away your ability to even see that report. Right. Because that's going to be ordered. If there's a post-sentence report, it's ordered after your representation is effectively over. It doesn't appreciably, it doesn't speed things up. What it does do is it saves their transport. Now, let me tell you practically where that could be an issue for folks. When people may get transported, depending on where they're transported, it can affect their housing. And it can do things like that. So if there's an internal reason that transport and going to court is causing them some concern, and talk to your client about that and see if that's something that needs to be investigated. But procedurally, it doesn't get them in front of the board any faster.
Yeah. In fact,
the other thing is APMP, I don't think they will even do pre-sentence reports on Class A's most of the time now.
I can't speak to that. It seems to me if a judge asks for one, they'd do it. But if they're not, I mean, we're going to get one. We have to know what happened.
We're getting one way or another.
Yeah.
And they will do them for us in terms of, at minimum, a post-sentence.
Mm-hmm.
And
okay.
so it's not moving things along. So the question then becomes, at some level, I'm guessing people are wondering, what can you do to affect things after that point? Fair? People wondering that?
Sure.
Say there's a question that you get a post-sentence report, because there are going to be some folks that absolutely will not let you do a PSR. That's going to happen. If there's an error, if there is something that you want to provide, documentation, anything that you want to add to the board file, you are welcome, and we encourage every participant, whether it's a defender, whether it's a prosecutor, to submit any information that they would like as it pertains to the case. And we aren't fussy. You don't have to do it on any special pleadings, any cover pages, and you can actually even email it to boppinfo@utah.gov. And we ask as a courtesy that you include the offender's name and offender number. It really helps us with filing. But the bottom line is you can provide us information that you feel might be beneficial in the case, and keep us updated that way as another avenue as you're working through the process. Be aware, anything you provide us will ultimately be disclosed to the offender. And so there have been times when people have wanted to, say, talk about maybe some sensitive mental health information or things that they didn't necessarily want to have direct conversations with the offender about. Just know that it absolutely is all, every bit of it is disclosed.
One other thing I wanted to touch on before we run out of time. If for whatever reason you have a case with someone who's in the prison on a new and a new offense has been alleged and charged, and you are pursuing a competency evaluation, if you could let us know that as well, because what we don't want to do is make decisions while your client might be incompetent. We just need to track that and follow up so we can get the same reports that you get, so we know what's going on with them. So if you file a competency evaluation, if you just send us a letter saying that that's what you're doing, that's helpful.
And please do not presume that we get copies of those evaluations from the trial court. We do not. The only way we get copies of evaluations like that is if you provide them or we are aware of them and we go to seek them after the fact. That is not something automatically that you can presume that we are going to be privy to unless you provide us that information.
And we have had a couple of cases where new offenses have occurred in the prison. They're going through competency evaluation, and we didn't know that there was a competency issue, and so DOC didn't know there was a competency issue, and so things are happening in one area as though they're competent. There's a competency. In fact, we had a finding of incompetence, and we just need to make sure everybody understands and gets the same report so we can deal with it holistically rather than, in separate silos. Other questions that you got with your cases or things that have happened or anything that you want to know about?
I've got another question here, and that is if one of my clients is going to prison on a sex offense, and then he knows he'll be probably going into the sex offender treatment program, but he's concerned that the therapist will ask him to disclose additional victims. And then if he doesn't do that, he will fail out of the program, and then the board will get will rule adversely against him. But if he then discloses, he waives his right against self-incrimination, so he's kind of caught in a binder. How does the board look at sex offender treatment program recommendations and why they're not doing well?
So the short answer to that is that the sex offender treatment program runs into that issue all the time, and they have the ability to inquire. I'm trying to think about the best way to phrase this. They know how to inquire in a way that will allow them to move through treatment and not incriminate themselves. So you're not going to get kicked out by talking about, they have a process for that, and it's something that they have to deal with, and they deal with it frequently. So go ahead, please.
We've been told by the therapists that the people can progress through treatment. What the therapist is looking about from a therapeutic is what different ages has this person offended against? Is there a gender difference between their offending? Because all those things go into their risk. But we've been told that the therapists are not asking enough detailed questions to result in a new referral to the police. And in 14 years here, I've only seen 2 cases referred to authorities from the prison, and in both of those cases, the offender is the one who contacted somebody else. It wasn't the sex offender treatment folks. So I think it becomes an obstacle that people use, but it's not really, it's a molehill by the time we deal with it.
My question was on the bottom of the agenda there, just how to help your client prepare for board proceedings. We kind of touched on that a bit, but.
Okay, the first thing that needs to happen is whatever brought them to you needs to stop. and we joke, but the bottom line is you all have a contract where folks are presumptively doing poorly in custody. They're doing poorly in custody and have picked up a new charge. First piece of advice to them would be stop, drop, and roll. Step away from whatever is causing you to get into trouble in the first place. We as the board, our mandate always and forever is to protect the public safety. And part of the way we do that is incarceration. Part of the way we do that is reducing risk. The offender has to show that they can reduce their risk and that they become a better risk to be released. That's really hard to make that argument if they're getting in trouble in custody. So lowering their behavior, their disciplinary write-ups, even for stupid stuff. What you'll see sometimes is you'll see, okay, well, I haven't gotten in a fight in a while, but I've had brew in my cell, or I'm testing positive, or things of that nature. That's still problematic. Stepping away from gang ties, doing things to more pro-social behaviors, participating in whatever programming is available. Even in the highest security levels, they can still do packets. They can still try and do things to be a little more productive during their time, things like that, to prepare. Open and honest conversations with the hearing officer. It's one of the few times where an offender is going to talk with the hearing official directly with no representation at that point. And so it's a really unique opportunity to have a very candid conversation.
The other thing that's very helpful is during your defense or representation of this person, if it turns out that something, you discover something that we might not know about, mental health issue, a physical health issue, a treatment issue, if the facts as alleged in the information that you got when you started the case turn out to be substantially different and your client has a substantially lesser culpability than was initially alleged or believed, all of that is important for us to know. And you can just write us a letter and tell us the new information, because it may be that we don't have it, and if you have information that seems different than anything we know, you should assume we don't know it, and go ahead and tell us, because we can go get information if we know to look, but we might not know before the hearing. And so it's always better for us if we know going into a hearing that there is a new issue that's just recently developed, or if somebody's got a place to live now that they didn't have before, or if they now have family support because you met with their family and then for whatever reason, maybe they burned their bridges before, but now they're in a situation where somebody wants to support them. If that's new information, all of that is very helpful for us to know. And that's sometimes captured in the pre-sentence reports, but if you don't get one, then we really don't have one, right?
That's a really good point. Release planning is often given sort of short coverage. What is going to be different this time from a previous parole, if they've had a previous parole? If you have not done well living with your mom, it may not be a good idea to go back and live with mom. Is there different and additional support? Are you on your mental health meds now? Are those things that are making you more stable? All of those things that are important and help people with their situations. Are they interested in medically assisted treatment if there's an addiction issue? All of those things can be helpful.
And when you talk to, even when you're resolving your case, your client, you can help your client get ready for our hearing by talking about the things that we're going to be concerned about, which are the behaviors that led them to have a new case, the guidelines for the new case, but more importantly, what they're doing or will do to reduce their risk and what the release plan is and how they're going to change. Because now you've got someone who did something that got them in prison in the first place, and now they've got a new charge, a new conviction. That looks a little bit different for a release plan for us. So they're going to have to start thinking to themselves, what am I going to say to the board about why they should take a chance on me if I get in trouble even inside the institution?
Is the board sensitive? And again, this is just, I'm one of the relatively new people, but I'm seeing a dynamic from doing this and then just prior cases where it seems like you've got an inmate and yeah, they did something here, but it was either do this bad thing over here or do this bad thing over there. They kind of, it's other inmates who kind of put them in these compromising situations, and so you can't kind of win for losing. I mean, is the board sensitive that that dynamic seems to be going on occasion?
We can be if we know about it, but as you can imagine, your client isn't likely to come to a public hearing inside the prison and tell us about that. Mm-hmm. And so if you find out, that could be something that you let us know.
Okay, but then they get retaliated against if they come forward with that kind of stuff. So just I'm getting that some of them are in a kind of a tough spot on some.
Right, but see, if they disclose it to you and you tell us about it, that's different than them in a public hearing telling us about it,
Mhm.
right?
How would we communicate? Just kind of back channel or this letter like you talked about?
The letter, yeah.
Okay.
But you told us that those letters are going to go to the inmate. They would be in the blue packet in their paperwork, and they never want any paperwork indicating that they ever cooperated with law enforcement ever.
That you will have to, that's something that you will have to manage because we are required to give that to them.
But a defender's explanation as to why he did this or that is different than cooperation too, right? We might not know either. I mean, they could be cooperating, we won't know, or they might have made what they believe to be the lesser of two bad choices. We don't know that either. All we know is what they did, unless someone
Right.
tells us something else.
Clark and Denise, this is Joanna, and I had to step out for a second, so I may have missed this, but did you talk about how the board looks at whether, specifically on an inmate who is charged with another offense, whether that person has pled or contested that second offense? Is that a factor that you consider?
You mean like if they're convicted at trial or plead out?
Correct.
No, that doesn't, we don't factor that in. We just look at whatever the commitment is when it shows up. And J&Cs don't ever say whether they went to trial or whether they pled. They just say they're guilty. And that's what we deal with.
What if they appeal?
We likely don't know they're appealing unless they tell us. But even then, we've had some folks who've filed an appeal and asked us not to have a hearing while the appeal's pending because they're afraid that they will have to say something that might make their appeal moot. And if they don't want to have their hearing, we don't make them. But I'm not aware of us ever taking that into consideration. We have when we read the cases that come out of the Court of Appeal, often people are on parole by the time the appellate decision about their commitment comes out.
The best way to manage sort of a thinking framework about the appeal, Joanna, is that we will presume the conviction as it stands is accurate. The facts in the file are accurate as represented and move forward in that fashion, pending appeal or not. If they receive relief, we have a procedure in place where we are notified and then move based on that relief. Does that make sense?
Yeah, it's really helpful. I was just thinking about the case law that says the board can consider those things, right? You can consider if someone's appealing against an inmate or against.
I mean, number one, none of us think that's fair. And number two, we rarely know it.
Okay.
I mean, we only know about appeals when the case comes out of the Court of Appeals and said, we affirmed or we're sending this back. Then that's when we find out, oh, there was an appeal.
No, that's really helpful.
And I'll just share, I've heard from other appellate attorneys that when they're advising people on whether to appeal or not, to take that into consideration. And most seem to advise that this will delay your board date.
It will delay if they request it. We have a policy that anybody, if they have a request a continuance, we're going to grant it for them. We don't want anybody to speak if they don't feel comfortable speaking. And particularly if they feel like talking about the facts would unduly prejudice them. What we will do is we will presume the facts and the conviction are appropriate as stated. And that's where I think the confusion lies, is because folks that are dealing with an appeal are by definition arguing that that is not the case. It doesn't delay what we're doing, but we will take the case as it currently legally stands.
We also won't delay, we won't delay on our own motion somebody's case from an appearance just because there's an appeal.
No.
We just don't do it.
Why would someone want to delay a board date? Because I'm guessing, let's say they prevail on the appeal, the board's going to revisit something sooner than, I guess, a date was set. If they wouldn't have had the hearing right while an appeal was pending.
So the problem on appeal where you really might want to consider delaying a board date is it was a case, it actually was one of the State versus Maestas cases, and statements that you make in a pre-sentence report can be used against you. You are under oath and on the record in a board hearing. If we are going to ask you about those facts. That's part of what we do. So if that is something that impacts the appeal, that would be a strategic decision that that client and that appellate lawyer would need to review.
But rarely, I mean, I can only think about 1 or 2 a year where someone will contact us, either the offender or the offender's attorney, and ask us to delay a hearing. Usually they're fine with the hearings going forward. And what makes them ask us for the delay, I don't know. I mean, we don't get into that. If they ask for a delay, we grant it. But like I said, often we'll read the Court of Appeals decisions on Thursday night or Friday morning, and it turns out that the person's already on parole.
So would the person, if comes before you and they don't want to testify or say something while their case is on appeal, is that going to be held against them, I guess?
No, that's just something that we won't have their participation. Right. They're welcome to have the hearing, but we're going to ask, and if they don't want to participate in that portion of it, that's fine too, and we've done it that way as well.
But a good thing to understand is what we're doing isn't really trying to rehash the facts. And so our interest in the facts is only to determine risk and what they did compared to what they're going to do next time, and how they've learned from what happened, things like that. So we're not rehashing everything that occurred. What we want to know about the facts are do they know what went wrong so they can avoid that in the future? That's kind of how we're looking at the case.
Just moving forward. Mm-hmm.
Yeah. So it's a little different than, like, did you do this on this day and then you did this on this, we try not to do that. We try to look at the facts. Okay, this is how you got here. This is what we need to consider. We need to consider victim impact, but where do we go here? What treatment modalities ought we be looking at as we look forward to a safe release?
How we got here and how we don't come back.
So for instance, if someone has an ag assault and it's because they're antisocial, that's someone different from what we're going to do if they have an ag assault and they were drunk at the time, because we may want them to go through substance abuse treatment in the one or cognitive behavioral therapy in the other. It's not going to initially add time. It's just, what are we going to do from here? What caused that to occur? So what do we need to look at in terms of risk for the future?
Thank you.
Any other questions? If not, thank you very much. Thanks for attending. Hopefully it was helpful.
Clark. Sorry. Thank you, Clark and Denise, enormously.
Thank you, guys. It's good to visit with you. Let us know if there's other questions that come up. We're always happy to help. We obviously can't ever speak on any specific case, but things like this where it's procedural, we're happy to be a resource, okay?
Thank you.
Thank you.
Actually, we'll have a CLE on October 16th by Monica Diaz, who is the new Sentencing Commission Director, and she will talk about the new sentencing guidelines that they're working on right now. So we hope that you can join us on October 16th. And then tomorrow we also have a CLE on the Supreme Court Professionalism Counseling Board by the board chair, and he will talk about that particular board and its role and how that affects attorneys. So hopefully you can join us tomorrow at noon as well.
And Denise and Clark,
everybody.
Denise and Clark, you are welcome to join those CLEs.
Thanks.
And you guys, if you're still on, there's the Lexis training at 1:30. If you can make that. If you didn't get that link, then email me. But that should be good. So thank you all.
Thank you.